Good morning, everybody. This is Jennifer, and we'll do our introductions here. But we're here to talk about, what we're looking at as far as leaves. I guess more specifically, we're going to be talking about the emergency paid sick leave and the emergency FMLA and what that looks like, especially more specifically associated with the interaction of the new Cal Osha regulations. So one of the things I didn't print out, Molly, was the first three slides. I think the first is to talk about FDEA, right? So
yes.
For those of you that are not familiar with the San Diego Employers Association, DEA is a nonprofit human resources consulting firm, and we have been around for over 100 years, probably getting closer to the 110 side of things now. FDEA, we do all sorts of things. Probably a lot of you have been to other of our webinars and maybe some of our other training courses, but SBA kind of fills either a void in maybe an HR department or works as a partner with the person that has the HR function in the company. And we can do things like handbook reviews, help onboarding your employees, do leave of absences, HR audits. So, not just the consultation, which is huge, being able to call in and talk to Molly or myself, or if we have to consult with an attorney, which I'm sure Molly can agree lately, we've had to do a lot of that with all this COVID stuff that's going on. So, anybody that wants more information about FDA, you can send us an email or something. So you're going to have Molly and I today. Again, my name is Jennifer Jacobus, and I am the Director of HR Services at FDEA. Molly and I pretty much do have the same functions at the association. Molly is, I'm not looking at your title, Molly. HR
consultant, yes.
Okay. And I think Molly's coming up. Are you coming up in your 2 years at FDEA?
I am, March 1st.
Yeah, it's very exciting. I'm sure it's flown by, especially the last year. So.
Both flown and dragged.
I know, yes. So Molly and I are here to help you, especially right now with everything that's going on with COVID. It changes on a day-to-day basis, as you will see our disclaimer at the end of this slideshow. Last thing I think before we get started into the materials is we'll field questions. We said an hour and a half for the webinar. So we did that with the expectation that we'll have a lot of questions. If you guys can use the Q&A at the bottom of your screen or top, I guess, depending on how your screen is set up. That way, especially now that Molly's the only one looking at these, she can just focus on one area and not using the chat. And plus, any questions we don't get to, we're able to pull reports off the Q&A, which we cannot do off the chat function.
Okay.
So.
All right. So into the leaves that are available on a voluntary basis, and you get tax credit. So, as probably a lot of you know, the FFCRA expired on December 31st, 2020, but then they made the determination, okay, we're going to extend it. We're not going to make it mandatory, but we're going to make it voluntary, and we're going to extend it through March 31st. So there's the emergency paid sick leave. So this is going to be exactly the way that it was before in terms of, the person gets 80 hours of paid sick leave for their own illness, or if they've been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. But when we start talking about CalOSHA, we'll see where that gets a little sticky. Or they're experiencing symptoms and seeking medical diagnosis, or they're experiencing another substantially similar condition, and the pay is not to exceed $511 in a day, 5,110 total. And it's just the same pool of 80 hours. So this isn't everybody gets a brand new pool of 80 hours. If they've already used their emergency paid sick leave, they're not eligible for it again. But if they haven't used it, you can still provide it and you will get the tax credit for it. The other one is the emergency FMLA. So that is using the paid sick leave for the first 2 weeks. So the EFMLA, they make it so confusing. The EFMLA is technically unpaid the first 2 weeks, except for you can get paid with the EPSL, and then you've got 10 weeks, and this is just due to school or daycare closure that's due to COVID. It's 2/3 pay, maximum 200 a day, or 12,000 overall. And with the emergency FMLA and the emergency EPSL, Chris Olmsted, our attorney, has said that you can pick and choose. So you don't have to do both. You can choose to do just one or the other. We got a question, if someone's been advised to self-quarantine, can we ask that they provide something? Oh, we're gonna get to that. Okay, so Jen, we're going into the CalOSHA interaction on slide 7.
Okay, perfect. All righty. So one of the big things I know that both Molly and I have been fielding a ton of questions are the new Cal Osha regulations that went into effect, end of November, right? So still, even though we are at the end of January now, unfortunately, there are still a lot of unanswered questions. And so we'll, again, field the questions we best we can, but some of these things that I think we all have questions to, there are not clear answers or guidelines to at this point. But, you know, we want to look at now the next few slides of how the emergency paid sick leave and or the emergency FMLA may interact with the new CalOSHA guidelines. So the CalOSHA, the exclusion interaction, and just real quickly on the exclusion side, because that's a big term that is used throughout the new Cal Osha regulations. You know, what does exclusion mean? And it's pretty simple, right? It's pretty self-explanatory. But when you, as the employer, are excluding somebody from the workplace, typically it's going to be an employee that has been exposed to COVID, somebody that has COVID, or somebody that has been that tests positive. They must be excluded, right, so that they don't potentially infect or expose other individuals, customers, clients, patients, contractors, whoever it is, to COVID as well. So looking at some definitions here under COVID-19 cases, defined as somebody who has a positive COVID-19 test. So they've gone and taken the test, they've come back tested positive. Somebody that is subject to COVID-19, a related order to isolate. And I think if we're looking at orders, you know, from the state, we know yesterday that the shelter in place or the stay-at-home orders, maybe that's what they're calling it, were lifted. And I think unless you're a restaurant or a professional person offers professional services, you know, such as hair and nails, it's probably not going to be significant difference for a lot of us right now as far as running the business is concerned. Or unfortunately, somebody that has died due to COVID-19. On the next slide, looking at the definition of COVID-19 exposure, I think if you guys have sat in other webinars or have read anything on this, you probably hear a common term of the 6-15-24. And this is important when you're looking at your employees in the workplace who have potentially, you know, been exposed. You have somebody that calls in and says, "Hey, I just tested," or you know, my husband or my spouse or my significant other, they were tested positive, so I went down and got the test, and I've tested positive. Of knowing what the term of exposure means, and knowing who to notify, and now who else may need to be, you know, excluded from your workplace. So CalOSHA has defined that as anybody that has been within 6 feet of a COVID-19 case for a cumulative, so it's a total of 15 minutes or greater, of course, within a 24-hour period. And one of the important things, because it's a question that we get a lot, it doesn't matter if there's some sort of a face mask or facial covering worn. If they meet the 6:15:24, 6:15, 15 minutes, 6 feet, 15 minutes and 24-hour period, that is going to be considered an exposure.
Right, and we got a question here, would the CalOSHA exclusion interaction only apply is exposed positive from work, not outside work? And no, the whole point of the CalOSHA order is that they're trying to stop the spread. So they don't care where you got it. We are going to talk about situations where it does matter where you got it, but for the purposes of excluding people from the workplace, and they really are, you know, that's kind of part of the reason why CalOSHA is saying that they want to maintain earnings, is because they want people to admit it if they've been exposed. They don't want people to be like, oh, well, you know, if I get excluded from work, I'm not going to get paid, so I'm just not going to tell anybody, and then they go give it to everybody. So, you know, the point is, if you've been exposed or if you're a case, they don't care if you're exhibiting symptoms or not. They don't care if you wore a face mask or not. They don't care if you got it at work or not. You're excluded from the workplace.
Right.
And then we've got a question, even if EPSL has run out, and yeah, we're going to get into some examples of that as well.
Yeah. Yeah.
So a lot of people, I think I'm actually on some of these questions, I'm going to wait till the end because we're answering them as we go along here. And then I'll scroll through questions at the end, and anything that we haven't spoken to, we can come to. All right. And as we're going through these exclusion interactions, I'm going to go ahead and just kick back to the previous slide. So, you know, with the emergency paid sick leave, one of the criteria is if you're subject to a federal, state, or local quarantine or isolation order issued by a local or state health official. So this CalOSHA order saying that if you're a COVID case or if you're a COVID exposure is a state health official quarantining someone. So that's why EPSL kicks in, because you've got the state health official saying you've been exposed or you're a case, so you have to quarantine. So then the next option of, are you eligible for EPSL? If you have been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Now, the CDC is throwing their 2 cents in, and also CalOSHA, but the CDC says that employers should not require a sick employee to provide a negative COVID-19 test or a healthcare provider's note to return to work. So with that, our assumption is that the CDC is thinking that healthcare providers are so overwhelmed right now that they can't be giving doctor's notes out, because they would spend their whole day giving doctor's notes out. So really, you just have to take your employee's word for it. And if they say that they've been exposed to COVID, or if they say that, that they are sick from COVID, then they are. And they get the emergency paid sick leave. If you're going to provide it, you get the tax credit, and hopefully this stops the spread.
Yeah, real quick too, Molly, just because I talked to somebody yesterday. They had an employee that was out for reasons that were completely unrelated to COVID, and they were out for a significant period of time, and they were asking me, what our policy is that we require people to bring a note that they're able to resume their duties, if they have some sort of a disability or something. And I think those policies, of course, you can still enforce and go forward with, but like exactly what Molly said, they don't want to overwhelm the system with having employers requiring notes to return people to work. But if you have somebody that's out because they hurt their back or they have a workers' comp situation and you require notes for them to return to work, that's a different situation. You can still uphold and comply with your regular policy.
All righty, awesome. Okay, so now going into the pay part, which is, if anybody attended our ELU last week, this is where Chris was cutting out and Jen and I were like, no, this is what everybody needs. So Per CalOSHA, employers need to continue and maintain an employee's earnings, seniority, other employee rights and benefits, including the right to their former job status. So it's job protected leave. But the big thing here is earnings. Now, this is only if they're excluded from work per the guidelines and otherwise able and available to work. So the guidelines being you need to exclude someone who's a COVID case, and you need to exclude someone who is a COVID exposure. Again, they don't care if they got it at work or not. They're a COVID case, they're a COVID exposure. If they are otherwise able and available to work, then you need to maintain earnings. Now, if the employee is unable to work for reasons other than protecting persons at the workplace from possible COVID-19 transmissions. So that includes if they're so sick from COVID that they can't work, then you're not, for CalOSHA's purposes, you're not responsible for maintaining earnings. Now, if they're so sick from COVID they can't work, they are eligible for the emergency paid sick leave. And again, you get a tax credit for that. So Jen and I have not come across any reason that you wouldn't want to take advantage of those tax credits. But, you know, if anybody wants to type into the Q&A a reason that they maybe have decided that they don't want to continue to provide the EPSL, EFMLA, we all learn from each other. So we'd love to hear that. The other exception is that the employer demonstrates that the COVID-19 exposure is not work related. So that might apply, like if the employee needs to quarantine because someone they live with is a COVID-19 case, well, that is going to be pretty clear that they're not being excluded because of COVID at work, they're being excluded because of COVID at home. The drawback to that is that the lack of pay may encourage employees not to report exposure. And again, that's going to end up making it go rampant. So Jen and I both, I think, recommend err on the side of doing what's best for keeping the employee out of the workplace. So, right. You know, I don't, and Jen, let me know if you disagree. I don't see any value in trying to fight providing them with pay that you're going to get a tax credit for anyway, because you don't want people who've been exposed to COVID coming into your workplace. Right. That's going to lead to way more headaches than this one person being out.
And I know, and you know, hopefully on this call or this webinar, and you guys have great employees that aren't doing this, that we've heard the phone calls of potentially some employees that may be trying to take advantage. And I know I fielded quite a few calls in December when we thought this was all going to go away, and maybe some employees thought that I'm going to miss out, quote unquote, free, you know, sick time or to take time off. But I really think that's the exception and that employees truly are, you know, if they're being exposed or they're sick, then we need to exclude them from the workplace. And I think the other thing here too, because I've also had this come up, is if an employee can work from home, they may need to be excluded from the workplace. But if they are not sick, like in the example Molly gave you, where they're not too sick to work, they've been exposed, they need to, you know, not expose their other coworkers, and they can work from home, then they just continue with their regular compensation and get paid for the hours that they're working.
Right. All right, so Jen, now we are on slide 12 with employee earnings is not defined.
Right. And that pretty much sums it up. It really is the biggest question everybody has, right? It's well, what does that mean in earnings? You know, they don't define it. You know, they've had different decisions on what regular rate of pay means. But it's the big question. And I think that was the part, even in our employment law update, where we're like, oh no, because Chris is cutting out. But he also didn't answer this question because there isn't an answer. So Cal Osha says that employers have to continue employees' earnings. What the heck does that mean, right? We do know that employers can use employer-provided paid sick leave benefits. So, you know, outside of the emergency paid sick leave, state of California as well as the city of San Diego have ordinances where employers are required to offer paid sick leave. So that is an option. There's, I think, questions on whether you can require PTO vacation, and we're going to look through some other scenarios right here. I think one of the things some of the scenarios that we're going to be looking at is on the third bullet, where employers may consider benefits from public sources in determining how to maintain inner earnings where permitted by law and not covered under workers' comp. We've been telling our members, if you have an employee that applies for state disability insurance and they get approved, let us know, because we're recommending that. And we finally did get, one of our members that had an employee that was unable to work. I think they'd exhausted their emergency paid sick leave and did apply for state disability and did get it. So that would be, as far as our interpretation goes, right, Molly, that is a continuation of benefits. The employee is getting some form of at least partial compensation.
Right.
I know also under these regulations, which can be a bit, Molly and I have also kind of gone back and forth on this, where it states on there that the employer may require the employee to exhaust sick leave benefits, and then I'm using finger quotes that you guys can't see, to the extent required by law. Which, what the heck does that mean, right? Because there's also, I think, some gray area on when you can and cannot require an employee to use sick leave benefits. But I think in this case, are we on the same page with this, Molly, that saying, okay, if you have an employee that's exhausted their time, you have 40 hours of sick leave, we're going to apply that because you're out.
Right. And I think, so if they did need to go out on disability still does have the 7-day waiting period. So they probably would want to use their sick leave for that waiting period.
Okay. Now I know didn't they waive that for?
That was unemployment that they waived it.
Oh, okay. All right.
And if I'm remembering correctly, it's waived for pregnancy. Yes, I think it's waived for pregnancy.
I know it's waived for baby bonding, but anyhow,
right.
Now we're going down a different road.
Yeah, we're not going to go down that rabbit hole. We're now on slide 13, talking about scenarios.
Yes. Okay. So let's look at some different scenarios where we're talking about the emergency paid sick leave and whether an employee has exhausted it or not. So in the first scenario, the example I just gave you guys, that state disability may be available if the employee is sick and they've exhausted all their emergency paid sick leave. So remember, Molly just stated a minute ago that this is not a new bank of time. So this emergency paid sick leave, the emergency FMLA, has rolled over into this year. Really what it is, it's an extension of the tax credit. So if the employee still has time available, they didn't use it last year, they didn't use all of it, then they can, if the employer is still offering the pay for their tax credits, they can do that. So in this scenario though, we've got this employee, they're sick due to COVID, they exhausted all their emergency paid sick leave already. So in this case, maintaining earnings does not apply because the employee is otherwise not able to work. They're too sick. It's not like we're excluding them from the workplace because they've been exposed. They are unable to work. And, a couple slides ago, we saw the term, where was it? Must be able and available. This is about protecting other employees in the workplace from getting sick. So in this case, they're considered disabled. They're too sick to work. So we would, as an employer, suggest and give them the information to apply for state disability insurance, and they would most likely be eligible for that. Let's remember too, excuse me, we see on the next bullet on that slide that the California Family Rights Act, CfRA Job Protection, is most likely going to apply. Not that even if it didn't, we would recommend terminating somebody because they were out for COVID. But as a quick reminder, CfRA and FMLA applied to companies that had 50 or more employees, but effective January 1 of this year, CFRA now applies to employers that have 5 or more employees. So that's going to be a giant change for a lot of you smaller companies that now are going to have to offer job protection if an employee is eligible for CFRA or if it qualifies as a serious health condition, which we were put this, somebody's applying for state disability insurance, we can pretty much put that in that bucket. And it also will require that the employer continue health benefits for up to 12 weeks in the same capacity that it was before the leave.
And another thing to really be thinking about with the fact that the CFRA job protection would likely apply is that, and especially for those of you who aren't used to it, CFRA provides 12 weeks of job protected leave, maintaining their health benefits. So if somebody is out because of COVID and, you know, and they're getting disability, you want to get that CFRA started because, you know, sadly, this could happen a few times throughout the year. And so if you don't put them on a CFRA leave and then something else happens again that they're CFRA eligible, then if you haven't made it clear that you were putting them on CFRA leave before, they're going to have their full 12 weeks, even if they use 2 weeks for this situation. So
right.
Hopefully
it's the employer's obligation to designate leave. So you don't have to wait for an employee to request, hey, I would like to take leave under the California Family Rights Act. They're probably never going to say those words. So it would be up to you. And the example Molly just gave you is going to be at your advantage to designate leave. So you're going to be providing them something in writing that says, you know, your leave, you know, due to your illness, also qualifies you for job protection leave under the California Family Rights Act, and explain to them what that means.
Right. Okay, so now we are on slide 14.
All right. So the next scenario we have here that we want to look at, so we have an employee, maybe paid family leave. So looking at the paid family leave may be available if the employee is caring for a qualified family member and they have used all their emergency paid sick leave. So in this case, maintained earnings does not apply because the employee is not otherwise able and available to work. So if the employee says in here they can't work because they're caring for somebody that is very sick and they need constant care and attention, the employee is not otherwise able to just simply be home with that person, which could also be a different scenario. You know, maybe a child or a minor or somebody that needs, you know, occasional care where they're working intermittently. But in this case, the employee is caring for a qualified family member, which under paid family leave is your spouse, your parent-in-law, your child, your grandparent, your grandchild, and your sibling. Did I get them all?
Yeah, I think so.
Okay.
Not your cousin and not your gardener.
No. So that's what's covered under the paid family leave. So we're not looking at maintaining earnings because this employee is not eligible to work. There are some circumstances, because I just kind of mentioned this, where maybe an employee can work part-time. And this would be kind of, you know what, I'm going to confuse things. So I'm going to save that comment for later. Again, just like we looked at the other scenario here, that CFRA could most likely apply in that example as well.
Okay.
All right. The next scenario, when we're looking at unemployment. So unemployment may be available if the employee is otherwise able and available to work. They cannot telework and they have exhausted their emergency paid sick leave. So this is a little bit different scenario, right? The employee is otherwise able to and available to work. So we have excluded them from the workplace. Maybe they've been exposed to somebody. Maybe we've got the county orders or state orders to close down. God, let's hope we're not going to go back in that direction. But let's just say hypothetically, we have to close our business, or we have an employee that has been exposed, but they're otherwise fine. They're not sick. They don't have any symptoms. they are available to work, they're not able to telework, their job does not allow them to do that, then as the employer, we should be looking at providing those employees with unemployment benefits. And, based on the information that we're getting from Cal Osha, that this should also be considered a continual or maintaining earnings if the employee is eligible for unemployment benefits.
Right, and maintaining benefits as well. So, and this could also be, in the scenario that we talked about, if somebody lives with someone who is a COVID-19 case, then they're kind of automatically going to be considered to be a COVID-19 exposure. Now, the thing is, and we're going to talk about return to work guidelines, this hopefully is not something that is going to easily go on forever, because you are able to return to work after typically 2 weeks. But of course, we can see scenarios where somebody lives with 8 people and those, they're all getting it one by one. So that's another. So all right, so return to work guidelines. So for a COVID-19 case, so that is somebody who, has tested positive for COVID, or, maybe their doctor said, yes, you're definitely a case, even if they didn't do a test or whatever, but they're considered to be a COVID case. They got it. It's going to be 10 days from the positive test date. Or the start of symptoms. So, if they're asymptomatic, you're just going to look at 10 days from the positive test date. If they're symptomatic, you're going to look at, okay, when did they start having symptoms? And then this is, kind of the same as before, and no fever. Now, they're now saying 24 hours. I know it was 72 hours at some point with all of this, but as of right now on CalOSHA, they are saying 24 hours, and other symptoms have improved. If you're a COVID-19 exposure, and this surprisingly is just very black and white, per CalOSHA, 14 days from your last known exposure. So, this is where if somebody has 8 roommates and everybody's coming back every 2 weeks, each roommate's coming back after 2 weeks from the last one having it, saying they have it, this could get extended, but again, that person could potentially file for unemployment. So, all righty. And, and then the CDC, in terms of number of days, has kind of gone back and forth on the number of days that somebody needs to be out. They've said 14, they've said 10. We're recommending just following the CalOSHA guidelines, 1, because they are just very black and white in writing, and 2, because if anybody's going to come after you, we think it's probably going to be CalOSHA quicker than it's going to be the CDC.
Yeah.
All right, so managing these requests for emergency paid sick leave. We strongly recommend getting a request form from your employees. And, if you need one, we've got a template that you can use. You probably maybe have one already. Reasons behind this are, 1, you want to have some kind of documentation for the IRS. So while you can't require a doctor's note for this, you want at least the IRS to see that, yes, the employee did request this. So it's proof that the employee requested it. The employee can't turn around and say, hey, I didn't really, request this. I didn't want to use it. You did this against my will. And then it also puts the onus of fraud on the employee. So if they're requesting it and it turns out that they really went to the Bahamas, that's not your problem. That's going to be their problem if the EDD finds out, or if the IRS finds out that, they're getting this payment and you're therefore getting the tax credit. So definitely, don't just say, oh, you got COVID. Okay, we'll see you in 14 days. Like, you want to put some structure around this. And then slide 18, reporting requirements. So this is something that's been a big question, and there's been some flippy-floppy on this as well. So you're going to report all cases to the workers' comp carrier, regardless of how it was contracted. So your workers' comp carrier needs to know about any case that happens with any of your employees. That does not mean that it's necessarily going to become a workers' comp claim, but your workers' comp carrier needs to know, and you'll need to reach out to your carrier and find out how they want you to do this reporting. As of January 14th, San Diego County said that they're requiring prompt reporting of all cases, which is weird because, like, if it's a case, if they tested positive, then where they got the test is reporting it to San Diego County. And sometimes the employer is getting a notice from the San Diego County saying this person has tested, is a case. And so then they're supposed to turn around and report again. We don't know. So we're just letting you know, San Diego County says that they're requiring prompt reporting of all cases. I would not be surprised if in 2 weeks, when they're overwhelmed with duplicate reporting, they change their mind on that, but this is what we know right now. The Cal Osha requirements are that you report to a local health authority only if you have 3 or more cases happen in a 14-day period. So that would be considered an outbreak, and that's what Cal Osha put together. You need to give notice of potential exposure to employees who may have been exposed. So it doesn't have to be your entire company unless the person who is a COVID case has, gone around and been within 6 feet for 15 minutes in a 24-hour period with every single person in your organization. But that's why you need to do your investigation so that you can, you do your investigation so okay, who might have been exposed and who was not. And then you also need to give notice to independent contractors. I think they're saying that just because an independent contractor isn't an employee, and other employers present at the workplace during the high exposure period. So this is present at the workplace. It's not who may have been exposed. So other employers would include like your property management company. If you are in a building that's shared with other businesses, you would need to let your property management company know that there was a potential exposure. If you share office space with another organization, any clients and customers who came in who were present during the high exposure period. All right, Jen, we are on to testing.
All right, so testing requirements. I think most of us have a pretty good handle on this, but the Cal Osha guidelines did say, reporting that we have to offer testing at no cost to employees who had a potential exposure in the workplace. Common question we get is, well, there's free testing available, and that's fine. It just cannot cost the employee anything. What if it's covered by our insurance? What if there's a copay? If there was a copay, which I don't think there is for vaccines, but hypothetically, then you would reimburse the employee or make sure that the employee did not have an out-of-pocket expense for the testing. One of the other things I was reading recently, that let's say you tell the employee, here, I called 211, here are some options for free testing for you to go to. We'll pay for your time, because it's another requirement, and the employee chooses not to do that. They want to go to CVS, and that's easier for them, and they have to pay, $10 or something like that. That's on them. That's what I just read recently, is that you have provided them the free testing and they chose a different option. That doesn't change, though, the fact that the testing should be offered during working hours, because you have to pay for the time that it takes the employee to get tested. So if that means they're waiting in a line, or they, there's some sort of delay or whatever it is, the employee gets paid for the time that they're actually getting tested. The testing requirements also require that the employer provide information on job protection and benefits pay. Also on the testing, for any employer that has multiple infections in the workplace, or what they call or considered a major outbreak, then the employer is also required to offer regular testing to their employees. So it's not like a one-off thing, like, oh, we've had an exposure, you need to go get tested, we'll pay for it, but if it's something that's happening on a regular basis, I was telling Molly, I think yesterday, I get, not exaggerating, every other day from my daughter's high school. They went back to school in January. Literally every other day, a note from the principal. Oh, it's the same exact letter every time. So when I think about, to me, that is multiple infections and outbreaks. I'm guessing they're probably testing the teachers and counselors and all that kind of stuff. So that's, like I said, you have to factor that in on how many outbreaks that you are having when we're looking at the testing. All right, vaccinations. This is another hot topic right now. And I think as the vaccinations become more readily available to the general public, outside of the healthcare workers and people in certain age brackets, essential workers, et cetera, this is probably going to become more of a question that we're going to be fielding. So, some of you guys listening may be making that determination right now. Are we going to require that employees get vaccinated? Are we going to suggest it? Are we going to make it available if they want to do it? Are we going to pay for it if they choose to do it? It's probably questions that are getting bounced around in a lot of people's workplaces right now. And we probably already know this, but for anybody that doesn't, vaccinations can be required. So as an employer, you can tell your employees, in order to return to the workplace, you must be vaccinated. I think, I don't know what you've been hearing, Molly. I think the few companies so far that I'm hearing from outside of the healthcare industry, because we've talked to, that makes sense, right? It's more business related. But I'm hearing more companies recommending it, providing information to the employees, more so than making it a requirement at this time. And that could change, like I said, as these vaccines become more readily available. The thing that we need to take into consideration, that you need to look at, is that if an employee claims or states or lets you know that they don't want to get vaccinated, we can look at a few different scenarios here. Let's say they don't want to get vaccinated and they claim it's for religious or medical reasons. So right now, per the EEOC, those are the two reasons that an employee may claim that they do not want to get vaccinated. For religious reasons, I don't want to, or medical reasons, I don't want to. So now we're looking at a reasonable accommodation, just like any other reasonable accommodation that you may be having to look at in the workplace. When it comes to the vaccination, as the employer, you need to show that if an employee chooses not to get vaccinated, so an unvaccinated employee would pose a direct threat to the other employees in the organization, or your client, your patients, or your clients, or your customers, etc. The EEOC is recommending that there's kind of a 4-factor test in determining on whether this direct threat exists, and that is looking at the duration of the risk, the nature and severity of the potential harm, the likelihood that the potential harm would occur, and the imminence of the potential harm. I know I was on the phone yesterday with one of our members in the attorney, because we had a healthcare facility and all the employees in the healthcare facility have been vaccinated except for one employee that said for religious reasons that she did not want to be vaccinated. And the religion is a little bit more difficult, right? Because I'm not an expert on religion, but there's all sorts of different religions, and we don't know what's allowed and what isn't. I know, like Christian Science, they generally don't do anything medically related to, as far as vaccines or even general health care or I'm trying to think of, helping people get better or from an illness or something like that. So that might be an obvious one that we kind of all know about. A little bit different than somebody claiming for a medical reason. because like other accommodations, we may, as the employer, be able to get more information on what they mean from a medical situation. So what the EEOC and what we're reading here is that employers can exclude employees from the schedule, but termination is not recommended. So if there's a direct threat that cannot be reduced, and what we talked about, just to share a little bit yesterday, what we talked about yesterday with this one employee that did not want to get vaccinated. And this employer did feel as if the employee wanted to continue working from home. And that may be more just their thought of why they were choosing religion and saying that they didn't want to get vaccinated. But they are going to have the employee come back to work and continue to wear the PPE, right? Again, they're medical facilities, so they have the N95 mask that she's going to continue to wear that, and a face shield. They're going to have certain restrictions for her. That's going to be the accommodation. As the employer, we're going to continue to provide PPE to bring you back to the workplace so that you can continue to work. When we're saying that the employer may exclude employees from the schedule, but termination is not recommended, then you have to look at, how long is that going to be a reasonable accommodation for? And I think like any other accommodation that Molly and I may ever talk to you guys about, it's always going to be recommended that the employer does everything that they can to try to accommodate the employee. And I think some of the things that employers are going to be facing, with this particular situation is if we have had employees working from home and now saying, well, I don't want to get the vaccine and you have to have the vaccine to come back to work. Well, if they were already working from home, is that considered a reasonable accommodation? And I think one of the things that Chris brought up yesterday, which I thought was kind of key with the accommodation side of things, is that in those cases, most of us were not accommodating our employees for medical reasons, right? So we weren't saying, okay, for medical reasons, as an accommodation, we'll allow you to work from home. Those are our employees were working from home because the governor and the city and state and the CDC and Dr. Fauci all told us that our employees should not be coming into the workplace. So that was, I thought, good advice, right? Well, yes, you were working from home, but that's because as employer, we were told that employees could not be coming into the workplace, and that is why we were making these accommodations for employees to continue allowing them to get paid, but that was not a permanent situation, and now we need people to come back to the workplace. Last thing I'll say on this, as I'm just ranting on here, that I think it's important that managers and supervisors that are responsible for communicating with their employees about compliance with the vaccination requirement need to know how to recognize an accommodation request. And kind of going back to this person that we were talking with yesterday, she started with, it's against my beliefs, or I don't believe in vaccines, until several conversations later, she finally used religion. It's against my religion. So, being flexible in that interactive process that we would use with any other accommodation is going to be important here. And you can get supporting documentation for medical issues, but that's just really not going to be feasible with a religious accommodation. All right, I'm off my stand now.
Okay, so now we get to our disclaimer.
Right.
So this information that we presented to you is based on everything we could find that was in place as of January 24th when I did the outline for the presentation. So things may have changed in the past 3 days. We don't know. We try to keep as up to date as possible, but like with the example of all of a sudden the San Diego County saying that you have to report every case to us. I was like, wait, what? When did that happen? And you're not necessarily hearing it on the news or getting it on your news feeds. So regulations are changing on a regular basis. We all learn from each other. So please share any knowledge that you have regarding employees' eligibility for SDI, paid family leave, unemployment benefits. And just with our members, you know, part of the membership is us all learning from each other. So whenever you hear some new rando thing, let us know.
Yeah, we appreciate it.
Yes, very, very much. So now it's your turn, and we, as expected, have a lot of questions that are in the list. So I'm just going to go ahead and go up to the top and start reading them. If questions come up as you are hearing the answers to other questions, please, please, please use the Q&A rather than the chat. That way, if there's anything that we need to you know, go and do further research on, we can run a report on it. We'll have your question there. If you use the chat, we can't do that. So we really, really need you to use that Q&A rather than the chat. For those of you who are going to need to jump off the call, the call is eligible for HRCI activity. So there's the activity code there, but we're going to go ahead and scroll to the top. So we've got a question. If someone has been advised to self-quarantine, we can ask that they provide something from health provider that says that. As of right now, CDC says no. Would the Cal Osha exclusion interaction only apply if exposed positive from work? No, it doesn't matter where they got it. Cal Osha wants you excluded if you have COVID. For OSHA 300 posting purposes, if COVID-19 positive test isn't work-related, does it have to be recorded? And Jen, I want to say no, because I believe—
I also want to say no, but that might be a question we can get back to you guys on. I can look. One advantage of me not being on the Zoom meeting is I can Google that while we're talking.
Right, exactly. I'm pretty sure that it doesn't need to go on your OSHA 300 record unless it is an outbreak, but we will work on confirming that. What is the difference between emergency paid sick leave and the CalOSHA exclusion interaction? So the emergency paid sick leave is the pay benefit that's available to people if they are out due to COVID. The CalOSHA exclusion is CalOSHA saying you got to exclude these people. So, you know, so CalOSHA is basically saying if you're a COVID case or your COVID exposure, you got to be excluded. Now, the emergency paid sick leave, because that CalOSHA mandate is there, like before, if somebody was exposed to, you know, if they thought they had been exposed to COVID, but they were not symptomatic and you know, I mean, this probably wouldn't happen if they ever reached out to their doctor, but their doctor said, oh, no, you don't have to worry about it. They might not be eligible for EPSL, but now because we've got that CalOSHA mandate saying, nope, you're out, it basically actually clarifies things a little bit better, makes it a little bit easier, because CalOSHA is saying, nope, you're excluded. So, you know, okay, I don't have to get a doctor's note. I don't have to worry about anything else. They are an exposure case. They're excluded. So we are, per the CalOSHA order, this person's out.
I'm going to answer the log 300 question.
Okay.
We're correct. Yay, yes.
Yay.
Do they have to record it? Yes. It must record a work-related COVID-19 fatality or illness. To be recordable, the illness must be work-related and resulting in one of the following, which goes death, days away from work, medical treatment, etc. This is important too. Does the COVID-19 case need to be confirmed to be recordable? Generally, yes. There's the however, though. However, due to testing shortages and a variety of other reasons, not all persons determined to have COVID-19 will be tested. So I think that's another one. If the employee's saying, I don't know where I got it, and nobody in my family has it, and they're saying they got it from work, then that probably needs to be a recordable instance.
Okay, excellent. All right. So Cal Osha exclusion is for anyone exposed, but pay at 100% pay is for work exposure only, right? No. So if somebody is eligible for the emergency paid sick leave, it doesn't need to be that they got it at work. If somebody has COVID or you know, has been exposed to COVID, it doesn't matter where they got it from. They still are eligible for the emergency paid sick leave. And then next question, even if EPSL has run out, I think we spoke to that, that if they have used up all of their emergency paid sick leave, then if they're sick, they might be eligible for state disability. If they are able, you know, otherwise able and available to work, but you have to exclude them because they have been exposed, then they could be eligible for unemployment.
And I think I'm going to interject again here real quick too. I think if we all kind of wrap our minds around with all these regulations that are coming out are really to achieve two things. One, to slow the exposure, to reduce cases, you know, people being in the hospital and all that. And two, that these employees that are being excluded from work, that we're not, you know, leaving them with a financial hardship, you know, that they're, and I know this sometimes means a hardship on the employer, but coming from the state, you know, the CDC, the Cal Osha, I guess specifically, we're slowing the exposure. They don't want these people in the workplace, and they don't want there to be some financial hardship put on them because they've been excluded from the workplace.
All right, excellent. All right, so what if the employee calls in sick for over a week, was told not to test for COVID by doctor, and is still out? Do they qualify for PSL? I would say yes, because they're falling into that, what's the phrasing, Jen, of advised by a healthcare provider?
Yeah,
got the slides.
Yeah, that's it. They've been advised by a healthcare provider. And I guess too, by the question, I know if somebody has symptoms, so if they're, you know, I have body aches, I have a fever, but my doctor told me not to test, but I can't come into work, then yes, I agree. They would be eligible.
Okay. And then we've got, I've told her to test. Do we wait for the test or pay her paid sick leave even without a test? You can't require a negative test, basically, again, with the idea that the purpose of all of these ordinances is that we are wanting to stop the spread and, you know, exclude people who may have been exposed. And a negative test today doesn't mean anything for tomorrow. So, so the whole idea of testing, and I know back before December, we were thinking, okay, well, you know, if you are experiencing symptoms, but then you test and it ends up being negative and then you feel better, then, okay, you should be able to come back to work. But that could be a little bit more gray now. So anyways, I don't know that that was helpful. Like, I fell down a brain rabbit hole. Okay, so we cannot require a negative test to come back to work. That's correct, even if they tested positive the day before. Well, if they tested positive the day before, they're out for 14 days. So that's that. So if an employee is sick and says they are negative but have COVID symptoms, should they quarantine full amount of time, or can they return to work when they say they are negative?
So read that again.
If an employee is sick and says they're negative but have COVID symptoms, should they quarantine the full amount of time, or they can return when they say they are negative? So, you know, so this is somebody who's got horrible hay fever. And with their horrible hay fever, sometimes they have shortness of breath, and sometimes they have a fever. It's called hay fever for a reason. And, you know, they don't feel good and they're really tired. So yeah, those are COVID symptoms. But if they test negative and they're feeling better and they're like, okay, I think that it was just hay fever and I'm fine, and the CDC is saying that you can't require a medical release back to work, then I think you got to let them come back to work. What do you think, Jen?
Yeah, I guess I would look at what the symptoms are, and that's hard too, because we can't probably ask a ton of questions about that. I might go back to that, and I know this is different than what Molly said earlier, but I may go back to the 3 days in that case, maybe without having any symptoms before I let him come back. But yeah, I think you would, if there's, I think we have to remember that people do get other illnesses other than COVID. So yes, I agree, Molly, yes.
Yeah, and I think this is another example of why you really want them to request the emergency paid sick leave, because you want to make it available for them. And if this person is exhibiting COVID symptoms and they're like, no, I don't think it's COVID, but you can say, well, if you did think it was COVID, this is available to you, but you need to request it. And just like you kind of have to take your employee's word for it. If they say, yes, this is COVID, or yes, I've been exposed, you kind of have to take your employee's word for it. If they say, no, this isn't COVID, again, you're going to want to be doing all of your measures of, taking their temperature before they come into work. And if they are still exhibiting those symptoms, even if they're like, no, it's hay fever, I'm fine, I can work. Well, no, if you have a fever and you are experiencing these symptoms, no, you can't come to work, because we're not going to take it for granted that it's hay fever, even if this happens to you every year in January when whatever pollen is released. So, and someone could have already exhausted EPSL. I think we talked to that already. Question about, for this situation, I'm not sure exactly what you're speaking of, but will the employer will designate CFRA and FMLA. So yeah, if somebody is out due to COVID, Jen, what do you think? At what point would you want to start saying this is CFRA leave, like at the beginning?
Well, I know in the FMLA regulations, which CFRA models them, that if you're out for 3 or more days, that's considered quote unquote a serious health condition, which is pretty much at the beginning, right? If somebody has told you, I've tested positive for COVID, and you know that they're automatically going to be the 10-day or the 14-day quarantine, then I think you can do it from the beginning, because you know how long they're going to be out. If it's somebody calling out for a couple days and they don't feel good, and I'm not going to come in today, or I still don't feel good, and then they tell you, on day 3, maybe I should go get the test, yes, then you're going to hit it. But a lot of these situations, I think we're going to know that the employee is going to be out for that period of time.
Okay. Is an employee still only eligible for CFRA under the same requirements? Yes. So CFRA is for an employee's own serious health condition, to care for a family member, or to bond with a newborn child. And COVID would be a serious health condition.
Right. If the family member is extended under CFRA, different under CFRA than it is under FMLA. So if you have somebody that needs to care for a family member, let's say you only have 20 employees who do not qualify for FMLA, but you do CFRA, or vice versa, or I'll throw a different scenario into you guys. Let's say you are a bigger company, you do need to comply. You've been complying with CFRA and FMLA for years now, but you have an employee that needs time off to care for their registered domestic partner's child. That's covered in your CFRA only and not FMLA. So your CFRA is going to start ticking away for the 12 weeks, but that bucket of FMLA time is going to sit on the back burner.
Right. And we're going to, let's not fall down that rabbit hole.
I know. That's a whole other class. Watch for that coming soon.
Yes, I think it's March 3rd. So, okay. We don't provide paid sick leave, we do all-inclusive PTO, but do we have to provide emergency paid sick leave to employee on top of PTO? You don't have to, it's voluntary now, but yes, it is in addition to your regular PTO. And again, you do get a tax credit for it. Okay, do we need to report to workers' comp a COVID case that happened with a remote only employee? Employee was never in the office, only in the home. And that is no. I'm right, Jen?
I'm gonna say no too.
Yeah.
Once in a while, Molly and I do confirm with ourselves that we have to use common sense once in a while. I did not think that was a bad question. But her and I bouncing things off of each other. It's like, right?
Yeah.
No.
Well, and we're reading stuff all the time too. So it's like, you know, I can't tell you exactly where I read this, but I know I read it. And for our members, please know that we are here for you for bouncing ideas off each other, saying, I want to say no, I want to say yes. So don't hesitate to call if you need to do what Jen and I just did.
Right. Sometimes just saying it out loud.
Yeah, it helps you kind of wrap your head around it. Okay, question about employee notice in writing. We do recommend the notice in writing and having documentation that the notice was provided as well. As Dan Eaton said in our employment law update last week, I don't know if I've repeated that in this webinar or not. If I have, forgive me. But COVID is moving faster than the speed of law. So, so if you are giving notice of potential exposure, you know, going up and saying to someone, hey, I want to let you know you were potentially exposed. If you don't have documentation of that, of the fact that you did that, and then that employee is disgruntled, and then they say I was never noticed or given notification, you don't want to have to deal with that. So, you know, kind of with any important employee communication, you want to have it documented. All right, we have a branch in Orange County and LA County. Our reporting requirements to the health services will be the same as San Diego County. Each case will need to be reported. In terms of reporting to your workers' comp carrier, I can say yes. In terms of reporting to the county, I don't know. I really just know San Diego. Jen, do you happen to know?
I don't know.
Okay, so yeah, you'll just want to go to those county websites and determine what their reporting requirements are. How long again do we need to keep the documents on file?
Which documents?
I'm guessing the documents like the notice of exposure. And Jen, do you think that would fall under your general employment documents that typically, well, the safest is 4 years after termination.
Yeah. It might fall under like your safety stuff, right? Do you think?
Yeah, probably
Like,
would fall under safety.
The same requirements for your, let me see, I can look up my record keeping.
Okay.
Chart
I know, this is awesome. We need to have you not be on the actual webinar more often.
Right? And just sit here and look at my files and Google stuff.
Okay. And also getting some stuff shared here with our participants. Thank you. On December 14th, 2020, Governor Gavin Newsom issued Executive Order N8420 called the Order, addressing a number of issues related to COVID-19. The order revises the provision in the newly adopted Cal Osha Regulations requiring that employees quarantine for 14 days, which aligns the Cal Osha quarantine standard with that articulated in an updated Department of Public Health guidance released in conjunction with the order. Cal Osha previously required employers to exclude from the workplace any employee who had close contact for 14 days. So it's saying the order suspends the more restrictive quarantine requirement. So yeah, lots of different people are saying different things, and then they're saying something different the next day.
Yeah.
So that's why we're just, err on the side of caution is my recommendation.
Yes.
That's all I
Yeah,
can
it's
say.
hard to keep up with. Yeah, Molly and I go through this all the time. We'll tell somebody something, and then the next day be researching, because we're always researching, say, oh, crud, I just told this person something different yesterday, but not on purpose. That's what we knew that day. And then it changed.
Right. So, that you've got the 80 hours, if they've got the 80 hours of emergency paid sick leave, I would probably err on the side of caution and keep them out. As with a lot of these things, you need to weigh the risk factors and the needs of your business
Yeah.
and, make the best decision that you can, taking all that into account.
Okay, so back to the record keeping question.
Yes.
So on here, we've got first aid records or job inquiries causing loss of work time. So I'm going to put that into this category. And it says 5 years.
Okay, awesome.
So, yeah.
5 years.
More paperwork, or hopefully
Yes.
electronic record keeping.
Okay. We've had a couple questions about the slides, and yes, we will go ahead and send the slides out to all of our participants today. Okay, and then this is more bringing the regulation in compliance with the updated December 14th CDPH. As a result, following a close contact exposure, an employer must exclude employees from the workplace, and an employee may later discontinue quarantine and report back to the workplace after the 10th day following the close contact exposure, so long as the employee did not present any symptoms associated with COVID-19 during the quarantine period. So again, in summary, Governor changed 14 days to 10 days to be in line with the CDC. Okay.
And I think that's what your slide said, though, isn't it, Molly?
No, because what's black and white in the CDC or on the CalOSHA order is 14 days. So if they corrected it, they didn't correct it on the webpage that has this order.
Yeah.
And it might get changed again. So we'll see. Again, you got to make the best business decision that you can, considering what the risk factors are, what the business necessities are. We are not requiring the vaccination. However, can I ask employees if they get vaccinated or not?
I'm pretty sure I read that you can ask, because it's not a medical, they're saying that that's not a medical inquiry. It's not like a medical exam or asking questions. You have employees that may not be truthful. I don't know why they would not be truthful, but I'm going to say yes to that.
Yeah, and I was reading yesterday and I read something as well that said that it wasn't considered to be a medical examination to, just ask about that. So
right, okay.
Okay. We had an employee that tested positive for COVID on Sunday. He started showing symptoms on Sunday. He was in the office on the Friday before. Do we need to notify employees that he came in contact with that Friday? Yes, because it's 2 days before either the positive test or exhibiting symptoms. And it's the, date of the test, not the day that they got the results back. Do we go back historically and report to workers' comp even if the employee was not working in the office? And for San Diego, if employee wasn't in San Diego County and was in November, do we still report? So I don't think that San Diego would want you to go back and retroactively report cases.
No.
That wouldn't.
No.
Yeah. And then in terms of workers' comp, if I'm remembering correctly, I'm pretty sure you have to report every case was effective January 1st.
Yeah.
So, yeah, so you wouldn't have to go back retroactively.
No.
Okay, can we require documentation be submitted if an employee is required to quarantine? Nope. The CDC is pretty much saying no. And again, we think that the reasoning behind that is that, you know, the healthcare system is so overwhelmed as it is that they can't be spending time writing out doctor's notes. You just need to trust your employees, and if it seems like they're abusing it, then address that. Okay, does EFMLA apply to companies that typically are too small to qualify for FMLA? Our company is 25 employees. Yes, actually EFMLA is 500 or less. Okay, I was under the impression that the EFMLA was extended until March, but beyond that, it has not been approved by Congress, and so it would be up to the employer to pay or not pay COVID absences. Is that correct? As of today, I believe so.
Yeah.
Okay. Does the Cal Osha exclusion apply for those critical infrastructure essential workers that were exposed? Yeah.
Read that again?
Does the Cal Osha exclusion apply for those critical infrastructure essential workers that were exposed? And I know there's differences for the healthcare, but in terms of just general critical infrastructure, I would think it still applies, because the point again being that you, well, let's see, because we did have somebody who submitted for essential critical infrastructure. The protocol has been that employees who have been exposed but show no signs can continue to work, but some employees say they have been advised to quarantine and want to call out. What do you suggest? And then we've got a link to a website. CDC's critical infrastructure guidance advises that critical infrastructure workers may be permitted to continue work following potential exposure to coronavirus 19, provided they remain asymptomatic, have not had a positive test result for COVID-19, and additional precautions are implemented to protect them and the community. And this is from the CDC. Don't know what the date is on that. So, but my guess is that CalOSHA came out later. So I think we're gonna need to, we'll have to dig into that one a little bit more. But again, with the idea being that you don't want COVID running rampant in your workplace, think about how you're best gonna attain that goal.
Yeah.
Okay. Da-da. Okay, sorry, I'd scrolled up to look at that other thing. So now I'm scrolling down again. Okay, the CDC has said that someone who recovered from COVID doesn't need to quarantine as a close contact unless they are experiencing symptoms again, in which case they would isolate. CalOSHA doesn't cover this scenario. If we had a COVID recovered employee who is in close contact of a newly diagnosed COVID positive employee, are we okay to allow the recovered employee to continue working unless they become symptomatic?
I say you have to follow the Cal Osha guidelines.
Yeah, I think.
Not the CDC.
Yeah, because again, who's going to come after you? CalOSHA or the CDC? Probably CalOSHA. So I would err on the side of caution and stick with the CalOSHA guidelines. Again, got to make the best business decision that you can under the circumstances. But CDC is probably not going to come after you. CalOSHA will.
Yeah. And I think too, the CDC is guidelines and CalOSHA is more, I mean, I think it's a regulation that we have to comply with. I'm not using the right term, but I think we have to remember the difference there.
Yeah, exactly. Because CalOSHA is a mandate.
Yeah.
So
and CDC, these are they don't really have any jurisdiction over in these, so they put out recommendations, these are guidelines to follow, but different from what CalOSHA is telling us.
Right. All right, we had an employee who claimed that was exposed at work and it was reported to the workers' comp. The final decision from workers' comp was found to be not work-related. Will this case need to be reported to the Cal OSHA as a reportable case? And you were just reading that about the reportable cases, Jen. Do you still have that up?
I think so.
That goes to that OSHA 300 log again.
Cases generally to be confirmed with a testing. Let's see. For record-keeping purposes, an experience illness is considered work-related if the event or exposure in the work environment either caused or contributed to the resulting condition or significantly aggravated a pre-existing injury or illness. So I would say no then.
Right, because if workers' comp.
Yeah, there's no work-related event that the state's on here, so no.
Right. Okay, we've got the County of San Diego can provide release of isolation letters if they have been tested by the county. So I guess that's in regard to the exclusion and letting people come back. So if the county has provided a release of isolation letter for your employee, then I guess you can let them come back. Although again, that's who's more likely to come after you, the County of San Diego for letting them come back or CalOSHA for letting them come back?
Right.
You know, I would say with, you know, with all of these things where it's like, oh no, we're loosening up, we're loosening up, we're loosening up, you really want to consider, okay, well, this person is saying that we're loosening up, but you know, if my employee turns around and says, well, you loosened up and CalOSHA says you shouldn't have, then is that an argument you want to have with an attorney?
Yeah, and I know we all have work reasons to get our employees back. I really want to balance out, you know, is another couple days or something going to make a difference of bringing this employee back to work versus potentially exposing other coworkers?
Right. And then we've got, can you confirm if we need to report positive cases to workers' comp if it is definitely traced to external sources, not at the workplace? Yes, you still do, because they were at work and they had it. So it doesn't matter where they got it.
Right.
Okay. And can we ask for a vaccine record or do we just take the employee's word for
it? If you're making it a requirement, then if it's required, then you can ask for it. I guess if it's not required, then you would.
Yeah, then why would you bother? Yeah, exactly. It's like, and Jen and I were talking about this the other day because there are companies that have been like, oh, well, you know, can we incentivize? And Jen, did you ever get an answer from Chris about incentivizing?
I brought that up. I asked Chris about it yesterday, and he didn't see an issue with it. He hadn't heard people doing that. I talked to one of our members and said, well, I'm sure you've heard about, you know, employers incentivizing their employees, which I hadn't, but then it came up a second time. So if it's, you know, hey, you get a $5 gift card for Starbucks if you get your vaccine, there didn't seem to be an issue from a legal perspective for that.
Right. And I was kind of comparing it to, you know, I used to work for a company that provided flu shots, and they were like, oh, you know, if you get the flu shot, like our healthcare provider came into the office and gave flu shots, and, you know, if you get a flu shot, we'll put you in a raffle for a, you know, $20 gift card or something like that. And that wasn't a problem. So it's sort of the same thing.
Right. Yeah.
Okay, I've heard the exposure period goes back both 24 and 48 hours for notification purposes. Can you confirm which it is? Thank you. CalOSHA is saying 2 days before, so we're
Yeah.
going with CalOSHA. I'm sure you could find a source that would say something different. we're going with CalOSHA.
Yes.
Okay, can you please clarify again what COVID matters need to be reported on the 300 log?
All right. So they're recordable if there is a death, which hopefully nobody's having to report that. If the employee had days away from work because of COVID, if they had restricted work or they had to be transferred to another job, medical treatment beyond first aid, loss of consciousness, or this is probably the bucket here, a significant injury or illness diagnosed by a physician or licensed healthcare provider.
Okay. All right, and we've got and we're at 11:30 and we've got not that many more questions. So I think we'll go ahead and stay on to answer these questions for a little bit longer. You okay with that, Jen?
I'm good with it, yeah.
Okay. All right, so we have an employee who has called out daily since January 19th. She doesn't know when she will feel better. She requested January 19th through February 1st for PSL eligible leave. If she's still sick, then when she fill out another leave request for continued FMLA CFRA leave, and FMLA CFRA begins on January 19th. So the person started calling out on January 19th because they were sick. At this point, she's saying, I think I'm going to be better by the 1st, which would make me think that there's probably some kind of medical certification. Now, the thing is you haven't identified if this is COVID related or not. So if this is just, she's sick, I would think that her doctor would provide her with, you're sick and you need to be out until February 1st. And that could be for any reason. So I would kick in the CFRA the first day they were out. What do you think, Jen?
Yeah, that's what I was going to say. So there wouldn't be a new leave or a new request. If this leave is CFRA or it triggers the CFRA and it just happens that she'll receive emergency paid sick leave benefits for a portion of her otherwise unpaid CFRA leave.
Right. All right, yeah, so the fact that she's using, if I'm understanding what the question is, the fact that she's using emergency paid sick leave doesn't make it not CFRA leave. It still is.
Right.
They would be concurrent.
Right. Yeah.
Okay. Oh, and we've got the release of isolation letters for someone that has been symptom-free for the required amount of time, but is still testing positive. And again, that's another reason why they're saying you can't require a negative test, because somebody may not be contagious anymore, but they're still testing positive. Like I've heard from members.
Yeah, I have too, that they like for weeks are, excuse me, still testing positive.
Right, yeah. Is asking and keeping copies of the vaccination record personal health information? If yes, then should it be kept in an employee medical file? Or can it be kept in the benefits HRIS system?
I mean, I would err on the side of caution and keep it in the medical file.
Right, and I mean, then depending on the benefits HRIS system, I would imagine that you've got proper confidentiality protocols in that information, that it would be essentially the same as keeping it in a medical file.
Right, yeah.
But I don't know about like asking for and keeping copies of a vaccination and why, but like, why would you want that?
Yeah.
I mean, I guess it kind of depends on your business too. There might be some businesses that are like, you know, yeah, we need to have a record of the fact that you've been vaccinated against the measles and the mumps and tuberculosis and all of that. And if you're that type of a business, then sure. If you're not that type of a business, then I just don't see why you would keep it, but you might have your reasons. But yeah, keeping it in the medical file. Okay, we have been applying and not having staff request emergency paid sick leave. We advise the employee that we are designated. We do not send designation notices as we normally would under CFRA and or FMLA. We do have an extensive HR tracking sheet. Should we start having people request the EPSL now? I don't want to appear discriminating. Yeah, I recommend that you have documentation that somebody has requested that they want to use emergency paid sick leave. And however that looks, if you've got, you know, some kind of tracking in your HRIS, but the main thing is you want to be able to show that the employee actually requested that they wanted to use the emergency paid sick leave. You didn't just arbitrarily start using it. Okay, and then we've got a few things that are in the chat, which I'm just going to scan through real quick. What documentation is needed for daycare closures for the 12-week option? The request form, and just tell us what school or care provider. So nothing too fancy.
Yeah.
Would the employer need to lay an employee off, or can the employee be active and apply for unemployment? Yeah, they could apply for unemployment if they've got reduced hours. So they don't have to be terminated to apply for unemployment, just like if you had furloughed them. And okay. All right, so I think that we got all of the questions. So thank you, everybody. Thank you for your questions and your participation.
Yep, thank you. You guys keep us on our toes.
Yes, definitely. And thanks for your patience with some of the technical difficulties that we were having.
Yeah, and I'll get over the fact that I have put makeup on for nothing.
Right. I think maybe you need to go out to lunch today.
Yes, and earrings too. I have earrings on. Oh,
wow.
All right, you guys. Thank you.
Thanks, everyone. We'll send the slides out in a bit, and yeah, we'll send those slides out. Take care. Call us when you need us.